A silence buried inside 89,000 pages of federal court documents is now screaming louder than anything the Department of Justice actually released. Something is missing, deliberately, methodically, and perhaps criminally missing, from the most anticipated document dump in modern American political history. The DOJ's release of the so-called Epstein Files, hailed by the White House as the ultimate act of presidential transparency, has instead ignited a firestorm over what was never included. At the center of this erupting storm is a woman, unnamed, protected, and terrified, whose testimony about Donald Trump may have been quietly erased from public view. Investigators, journalists, and former federal prosecutors are now asking a single devastating question: who removed those pages, and on whose order? The Epstein Files Transparency Act was passed with bipartisan support and signed amid promises that every buried secret would finally see daylight. But daylight, it turns out, was carefully controlled. What has emerged in the days since the release is not just a story about Jeffrey Epstein. It is a story about power, protection, and a paper trail that someone did not want you to follow. At least one witness, interviewed multiple times by the FBI in 2019, is missing 3 of her 4 interview memoranda from the public production. That witness, sources confirm, is the same woman who accused Donald Trump of sexually assaulting her when she was between 13 and 15 years old. The discovery was made through painstaking cross-referencing of case indices listing every document produced to Ghislaine Maxwell's defense team ahead of her 2021 trial. Those indices assign a unique numerical identifier to each document, and when reporters mapped those identifiers against what was actually released, the gaps became impossible to ignore. More than 500 witnesses are listed in the production index, each assigned a sequential case number tied to a specific list of documents. But for this particular woman, the math does not add up. 15 documents are supposed to exist, and only 7 can be found. The missing 8 documents include 3 FBI interview memoranda, generated across a rapid succession of sessions in the summer and fall of 2019. Independent verification by at least 3 separate journalists and news organizations has confirmed those documents are simply not there. What makes their absence so alarming is what the one available interview memo does contain, and what it conspicuously does not. In the single interview document that was released, the woman makes no direct accusations against Trump. She says she met him once, without elaborating, and declines to describe the encounter in detail. But there is one chilling detail buried inside that single available memo that has stopped seasoned investigators cold. When FBI agents asked her how she first understood that Epstein had abused her, she retrieved her phone and hesitantly showed them a photograph. The photograph was a well-known image of Jeffrey Epstein and Donald Trump together. She was reluctant to display the full image to federal agents, according to the memo, because someone else appeared in the frame. She told investigators she feared that person could retaliate against her if their presence in the photo became known. That statement, preserved in the one document that survived the production gap, raises immediate questions about what the missing 3 memos might contain. A separate FBI internal presentation compiled in the summer of 2025 makes the connection explicit. That presentation, reviewed by sources familiar with its contents, identifies this woman as a witness who accused Trump of sexual assault and physical abuse. According to that presentation, the alleged assault involved forcing her to perform a sex act and also included physical violence. The woman was between the ages of 13 and 15 at the time of the alleged incident. None of the alleged abuse is said to have occurred in Florida or New York, the 2 states most closely associated with Epstein's criminal network. The location has not been disclosed publicly, adding another layer of mystery to an already labyrinthine case. When NPR first reported the missing documents earlier this week, the White House did not address the substance of the gap. Instead, a spokesperson issued a statement describing Trump as the most transparent president in American history and insisting the administration has complied fully with the Epstein Files Transparency Act. That response satisfied almost no one who has spent time inside the files. Legal analysts noted immediately that compliance with the act cannot be claimed if documents specifically listed in the production index are absent from the public release. The Epstein Files Transparency Act contains an explicit prohibition on withholding documents for reputational reasons. If a document was suppressed to protect the reputation of a sitting president, legal experts say, that would constitute a direct violation of the statute. Former federal prosecutors who reviewed the available evidence said the pattern of missing documents does not resemble a clerical oversight. Documents are numbered consecutively with an EFTA prefix, Epstein Files Transparency Act, and a specific page number, making accidental omissions extremely difficult to explain. By tracing those page numbers against the gaps in the index, NPR calculated that more than 50 pages are unaccounted for in this witness's file alone. The missing page count is consistent with 3 full FBI interview memoranda of typical length. What compounds the concern is that the missing documents are not randomly scattered throughout the file. They correspond specifically to interviews conducted after the woman had already disclosed her accusations, suggesting the FBI knew what she had said and chose to interview her repeatedly in response. Legal analysts describe a witness interviewed by federal agents 4 times in a single year as someone whose testimony was taken extremely seriously by investigators. The Bureau does not invest that kind of time and resource in an allegation it considers implausible. And yet, the official DOJ statement released weeks ago suggested the opposite, describing certain claims against Trump as untrue, sensationalist, and timed conveniently before the 2020 election. That preemptive dismissal now looks to many observers deeply suspicious. The statement declared that if the accusations had any credibility, they would have already been weaponized against Trump. But critics note that accusation ignores the central reality. The accusations were never fully disclosed to the public until now, and even now, key documents remain missing. Members of Congress who supported the Epstein Files Transparency Act are beginning to call for accountability. Several have indicated they will seek an explanation from the Department of Justice about the specific documents identified in the production index that did not appear in the public release. The broader pattern of inconsistent redaction has added fuel to those demands. Some individuals in the files received heavy, protective redaction, their names blacked out, their roles obscured. Others, specifically survivors and alleged victims, received far less protection. Legal advocates for Epstein survivors called the selective approach to redaction a betrayal of the act's intent. They argued that the law was designed to protect victims while exposing perpetrators, and that the current release has done something closer to the reverse. The woman at the center of the missing documents has not spoken publicly, and her identity remains protected. Sources familiar with the case say she has lived with the fear of retaliation for years, and that her reluctance to show agents the full photograph was not an isolated moment of caution, but a reflection of long-standing terror. That terror, investigators say, makes her silence now all the more significant. A woman who was brave enough to sit across from FBI agents 4 separate times in 2019 has been effectively silenced again, this time not by fear, but by missing paperwork. The DOJ has not responded to specific questions about who reviewed the documents before release, what criteria were used to determine what was included, and whether senior officials were aware of the production index before the files were made public. Those questions are now circulating in congressional offices and legal advocacy groups simultaneously. Inside the department, sources say hundreds of assistant U.S. attorneys and staff attorneys were involved in preparing the documents for release. That massive review process created numerous opportunities for documents to be held back, and numerous people who might have witnessed that process. Whether any of those individuals will come forward remains unknown. But the existence of the index itself, a document that lists what should be there, means that the absence of specific files is now a matter of documented record, not speculation. The index was produced to Ghislaine Maxwell's defense team during discovery proceedings, which means it represents what the government itself identified as the relevant body of evidence at the time. Any document listed on that index and absent from the public release demands an explanation. Maxwell's attorneys had access to materials that the American public still does not. That asymmetry, where a convicted sex trafficker's legal team saw things that voters and journalists cannot, has struck many observers as deeply wrong. Legal scholars note that the production of documents to a criminal defendant's defense team carries significant legal weight. Those documents were reviewed, organized, and numbered precisely because they were deemed material to the case, material enough to share with Maxwell's lawyers. If they were material enough for Maxwell's lawyers, the argument goes, they are material enough for the American public. The Transparency Act was written with exactly that logic in mind, and its apparent violation is now a legal and political emergency. Former Manhattan prosecutors who reviewed the available information said the missing interview memoranda would likely have contained the most detailed account of the witness's allegations. Interview memos prepared by the FBI typically include verbatim or near verbatim summaries of what a witness said, the questions agents asked, and any supporting details the witness provided. 3 such memos, 3 separate sessions, would amount to a comprehensive record of one woman's account of what she says happened to her. That record, if it existed and was removed, represents not just a legal problem, but a profound human one. Political observers noted that the timing of the document release, just before a major presidential address, placed the story in an uncomfortable spotlight. Epstein survivors and their families had been invited to attend the event, and the question of whether the president would acknowledge their presence hung over the evening like a storm cloud. He did not acknowledge them. He did not reference the files, the survivors, or the missing documents. The administration offered no comment on the gaps identified in the production, and no official has yet been asked to testify about what happened. Former Congresswoman Marjorie Taylor Greene, who played a key role in the discharge petition that forced the release of the files, has since described pressure from Trump himself to prevent their release. She said he told her the files would hurt some of his friends, a statement that now resonates in a new and darker way. Greene is no longer in Congress, having been targeted by Trump in her primary race. Her absence from the chamber removes one of the loudest voices demanding answers about the files, a political consequence that some Epstein advocates describe as chilling. The question of what the FBI knew in 2019 is now central to any honest accounting of the missing documents. The Bureau interviewed this witness 4 times in a single year, a level of engagement that suggests the allegations were being actively investigated, not dismissed. And yet, no charges related to those allegations were ever brought. No public disclosure was made. The investigation, if it continued past 2019, left no visible trace in the public record, until now, when the traces it did leave are themselves disappearing. Advocates for transparency in the Epstein case have warned for years that the full scope of his network would never be voluntarily disclosed. They pointed to the 2008 non-prosecution agreement in Florida, widely criticized as a sweetheart deal, as evidence that powerful institutions protect powerful people.